a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Your Talkback lawyer is in the building. Well, not this building, but his building at least. And he's ready to dispense some free legal advice. David Whiting, Melbourne solicitor and man about town. Good morning to you.
Good morning, Virginia. I'm looking forward to being a man about town now that I can.
Yeah, so am I, and I'm not even a man.
Well, I've already booked the first restaurant.
So have you?
Yes.
For when? Tomorrow?
No, the second.
Fantastic. I won't ask you where you're going, but is it lunch or dinner?
Dinner.
Is it with your significant other?
Yes, I have two significant others. I have a wife and a daughter, and it's all three of us coming. Yep.
That is just lovely. I've got something similar organised for the following Friday. Cannot wait. We've got some lines coming in, but some lines free. 1300 222 774. If you have some pressing legal matters that you can't figure out on your own or you'd like some advice on, David Whiting is here to help you. 1300 222 774. We had some homework from last week, and this must be a problem that plagues many people. It's the dreaded noise from another apartment dweller in your block and what you can or can't do about it. Remind us of the story, David.
Well, Julie rang from West Melbourne, and in an adjoining block, in one of the units in her block, there was a tenant who liked to play music very loudly. And there wasn't a great deal of satisfaction coming from the Owners Corporation, and a complaint had been made to council and no success there. An attempt made to dispute resolution centre, but that didn't go anywhere because that requires everybody to recognise that there's a problem and work together to resolve it. In fact, the other side didn't respond, and it's an entirely voluntary process. So the question is, what does Julie from West Melbourne do? Well, the Owners Corporation list at VCAT. It's an action brought by Julie against the tenant, and so it's not against the owner of the unit complaining about the tenant, it's from a neighbour complaining about the tenant. And every Owners Corporation has a set of model rules, has a set of rules, and the standard rules, which would apply to 99% of Owners Corporations in Victoria, says that an owner or occupier of a lot or a guest of an owner or occupier must not unreasonably create any noise likely to interfere with the peaceful enjoyment of any other person entitled to use the common property. And the first case I found was a glorious case about a lady in South Yarra who kept pigeons. And the question was part of the question that needed to be resolved was whether the cooing of the pigeons was annoying to neighbours. And that case was unsuccessful from the point of view of the complainant. But I did find at one from 2012 which addresses Julie's issues perfectly. And in that case, the applicant complained that when the neighbour used his sound system to play recorded music or watch television or DVDs, the bass was played at such a high volume that it made the windows in the apartment rattle.
Yes.
So, and the answer was there was a civil penalty order made against the owner, against the tenant or the occupant of the unit, that the occupant cease and desist the noise. So there was an order made.
By what or by whom?
By VCAT, under the Owners Corporation Act. And in the event that the order is not complied with, there are civil penalty provisions contained in the legislation. So there are some sanctions that are available. If Julie is listening, the website that you find these things on is called Austli, AUSTLII.edu.au. And the case is called Boglis, Boglis, against Adams, and it's from 2012.
That's where you find all the legal cases and all legal documents, Hostley. Great place to go. I hope that's of any help to you, Julie, and thanks for calling in last week. David's here to answer your questions, to give some advice. Leon in Reservoir is first up. Hi, Leon.
Hi, folks. David, recently I went to a nursing home, and in its skip I found possessions and a will of a deceased resident's. And I contacted the nursing home about my findings, and they told me to mind my own business. I contacted the lawyer on the will because he's the executor. He asked me to email him the copy, and I did. And I told him that I've got possessions of the person at home, and I want the will to be executed as the person wanted. But the lawyer is not contacting me or answering my emails or phone calls when I'm asking him where he's progressing with...
Do you have an interest in the estate, Leon?
No, I don't have an interest in the estate at all.
Then why when a person makes a will, they nominate an executor.
Yep.
That doesn't compel the person named to do anything.
Yeah, okay, but the executor is the law firm.
The law, yeah, I understand that. But to appoint someone executor in a will is to say, I want Fred or Mary or whatever it is to administer my estate, to collect my assets and pay my bills. And sometimes you come across an estate where there are no assets but simply liabilities. And I'll give you a story. I was appointed an executor by a doctor who, when he died, had no assets whatsoever. And that's when I found out that being the executor of a medical practitioner made you responsible for the retention of his medical records. Mm-hmm. So it wasn't the most thrilling job I've ever taken on. So, and it might well be that the executor, the person named, doesn't want to be the executor. And so it's in that person's best interest to do absolutely nothing.
In which
case you talk to the beneficiaries.
Sure, let me jump in here. Leon, you clearly want this person who died, you want their rights and their wishes respected. That's why you're doing this, yes?
Spot on. And he has assets. He has a house. He has money in the bank.
Yeah.
Then you should talk to the beneficiaries, Leon.
The beneficiaries are his relatives in Serbia and a institution.
Then after a period of time, you can refer the matter to the Supreme Court with a view to the Supreme Court appointing someone to act in lieu of the executor who's doing absolutely nothing. There's a requirement in the Administration and Probate Act for a will to be brought into court, so you might consider that application.
Well, okay. I also spoke to state trustees who were managing the person's affairs.
Yes.
And they also asked for the copy, and I gave it to them. And I said, are you going to execute? Are you going to try and get these positions off me? And they said, no, we're not interested. It's up to the executor.
Right.
Now that you're saying, David, that I have to go to the Supreme Court and do this.
No, well, why don't the beneficiaries in Serbia appoint someone to do it?
Well, that's if they know if he's dead.
But that means Leon has to kind of track them down and contact them and make them aware of it.
Then why not refer the matter to the Legal Services Board? But at the moment, I don't think the lawyer's done anything wrong. It certainly hasn't delivered as one would expect the person to. Mm-hmm. But that's if he doesn't have to take on the job if he doesn't want to.
But there's an undistributed estate there that just sits there, does it?
Who's going to execute the wishes of this dead resident?
Ultimately, state trustees will.
Well, they've just told me they've wiped their hands off it.
Yeah. Well, no, right here and now, they have no power and no capacity. They have no ability to do anything today. But after a period of time, and I'm not sure what the period is, but it's probably 12 months, they have the right to step in and take over the administration of the estate. But today they don't.
Leon, we have to move on, but Leon, can I ask you, was this person a friend of yours?
I had met him because my mother was in the same nursing home.
Right.
Yeah.
But I would be incredibly disappointed that the original will's been thrown out by the nursing home, so I'd be talking to the aged care people because somebody, or it could be that it was somebody simply living there who had no visitors.
That's a possibility, but his items were thrown out in the skip, and I found it quite easily, and I contacted the Aged Care Royal Commission, and they said it's out of our hands. I contacted the Office of Public Advocate. They said we can't do anything about it. I just see a whole system here where there's no responsibility.
I agree with you, Leon, and I'm going to pop you on hold because I want your details because I think just that very first fact of a will in a skip is the one that's got my attention and needs to be dealt with. Leon, I'm sorry we couldn't absolutely resolve that today, but we'll stay in touch with you. Thank you. Margaret's in North Ringwood. Hi, Margaret.
Oh, hi, Virginia and David. A girlfriend of my daughter's, she's just built a new house 6 months ago they've been in, and the next door neighbour has a tree, and they'd had the tree assessed as dangerous, but they hadn't found anybody to come and chop it down. And then this week, that tree's fallen over and damaged my daughter's girlfriend's house.
Yes.
And she's been told that she has to pay the $500 excess on the insurance because the neighbour's tree fell on her house and damage came through the lounge room roof and wall, etc. I mean, they've just moved in. She's got 2 young children, really can't afford to pay $500. But why is it her responsibility and not the person that owns the tree's insurance company?
Well, the nature of insurance is that your daughter's friend is making a claim on your daughter's friend's insurance company to say, my property has been damaged, I need to get it fixed. And what the insurance company then does is go and make a claim on the insurance company of the person who owns the tree. So your daughter's friend could leave the matter entirely to the neighbour and the neighbour's insurer, or could make a claim on her own policy.
Well, the neighbour sort of said, well, no, it's her responsibility and her insurance isn't going to pay it. The neighbour's insurance says they're not paying.
Not paying what?
Not paying. Well, they want the excess. They want the
No. Let's split this into 2 questions. From what you're telling me, the person who owns the land on which the tree was growing has a liability to the owner of the house next door for damage caused.
Right.
Now, the person who owns the tree can go to her insurance company and say, my tree has damaged my neighbour's property. I want to make a claim on my policy so my neighbour is not out of pocket. And the insurance company then says, for making a claim, you've got to pay the excess. The option is that your daughter's friend then can also say, my house has been damaged by the neighbour's property. I want you as my insurance company to fix it and pursue the neighbour next door for any damage. But in order for your daughter's friend to make a claim on her insurance company, she needs to pay the excess.
Right. Which can be refunded.
No, it's not refunded.
Okay.
It's not think of it in a car accident. If you and I have a car accident together, if we both make a claim on our insurance company, we both pay an excess unless you've got a policy with a no blame element in it. But you pay for making the claim.
Right.
Good luck.
So if the $20,000 worth of damage, you pay the first 1,000 or the first 500 or whatever it is.
We'll move on. I hope that's helpful and helpful to the friend of your daughter. Thanks for calling in. And Noura's called in from Taylor's Lakes with a common problem. Hi. And Noura, go ahead. Good morning.
Morning for both of you.
Yes.
I just want to know with regard to the law behind this marking a chalk line on a tyre.
Mm-hmm.
I had an infringement. It's a small amount, it's $80. But just when I had this chat with the city council, they said they mark the tyre only at the time they are issuing the ticket. Then the pictures on the internet says that it's only 3 minutes apart. My understanding was they mark the tyre at the beginning and they mark the tyre when they take a picture at the beginning and also take a picture after the time has lapsed. And they say they don't do that. I just want to clarify that matter, please.
It's my understanding, from my observations, Aruna, are that they come along and if they find a car that's appropriately parked but with no, so there's no meter or anything, then they will simply mark the tyre with the approximate time that they came past. So that's the starting point for the parking, and they then come back, whether let's assume it's an hour's park, they come back an hour and 20 minutes later, and if the car is still there, then they will give you a ticket for the car.
Mm-hmm.
That they don't do that.
Well, now they take lots of pictures, and they are also lots of car parking bays have sensors in them. So there's an electronic device that tells whether the car's being moved or not.
Had your car been left there beyond the allowed time?
No, what happened was it's a 1 hour slot.
Yep.
I took it out before the time lapsed, and I reparked it there, and bays are not marked there.
Hang on. Did you repark it in the same slot?
There are no slots. It's like a long stretch. So it's a similar area, but about 1.5 meters apart.
A different space. So a similar area, but a different space. What do you reckon, David?
Aruna, here's the catch. Let's imagine that there are 2 driveways and there are 4 car parks in the middle. And at the one end of the 4 car parks, there's a sign that says, with an arrow, 1 hour parking, and there's a 1 hour parking sign at the other. So the 4 car parking spots are covered by the one pair of signs. If you park between the 2 posts for 1 hour, even in a different bay, if they are consecutive, you have broken the rules.
Right, okay. So you've got to go to a completely different area.
A different set of signs.
Different set of signs, okay. I think that's the problem there, Anura. Sorry about that.
All right. Thank you so much to both of you.
Yeah, no worries. Good to hear from you. Thanks so much. Tom is in Melton. Hi, Tom.
Hello. How you going, Virginia?
Good,
How you
thanks.
going, David?
Good.
Hi.
I've got an unusual one. Someone with a disability with an acquired brain injury, is it normal if they've asked for representation, they are a road victim, to self-represent in local courts, county court, federal circuit court and the family court?
You are entitled to be self-represented, to represent yourself if you want to.
No, that's not what they're wishing. They are wishing to be represented, but continuously being ignored. They ask even Your Honour, and Your Honours just completely dismiss it. It's all documented.
So what are they asking the judge to do?
Well, are they entitled to legal aid? Because who is their representation being a road victim? They're on limited finances.
Yes.
It is a benefit. They fall between the gaps. Legal aid sometimes will take them on, then sometimes won't take them on. It's just there is no consistency when they're asking for representation and then having to self-represent again in the county court or in the Federal Circuit Court of Australia. Okay. To self-represent, I mean,
well, I
is
would,
this normal?
Sure, I would have thought you'd be entitled to aid. David?
Well, but legal aid doesn't have bottomless pits of money. I mean, legal aid has to budget what they've got and they need to, and what legal aid does in a sense is does a value assessment of whether or not it's a matter which comes within their guidelines and is an appropriate spend of money. So, for example, sometimes you will get legal aid to assist with a plea, so a plea of guilty, and they'll put arguments in response to that go to penalty, but they won't fund what might be a 2 or 3 or 4 day trial to dispute whether or not liability exists. So the disability of the person involved is a factor that legal aid take into account, but it doesn't automatically mean that legal aid will always be in a position to provide every person who seeks representation the representation that the person seeks.
And Tom, is the problem that this person can't afford their own lawyer?
That's correct. And again, it's just continuously happening. Again, at the moment, it's in the children's court, fighting for his children, and again, having to self-represent. I mean, it's just...
it sounds like a really rough situation. Is there any other place that Tom's friend can go to, David?
Well, he can talk to the community legal services, but it might be that the people who he wants to get advice and assistance from don't share his perceptions as to the possible outcomes. Because if you go to someone for advice and assistance, and they believe that you're a hopeless case, how much advice and assistance do you think that they're obliged to give somebody like Tom's friend?
Of course, but at least a conversation might be able to be had,
Yes.
and perhaps that could be
Yep.
assessed. So,
Yes.
Tom, that's probably the best advice, maybe a local
Be
community
looking at
legal
some
centre.
community legal services and have a better
Been
discussion.
there. It's too overwhelming for them. My point being again is, how do judges keep expecting a person with a disability to self-represent in court?
Yeah, I think it's a perfectly fair question, and I'm very sorry that we don't have an answer for you. Thanks for calling in, though. Nonetheless, I'm uncomfortable leaving it at that place. But David, is there anything further we can say on this, apart from
No,
the inherent
it's
unfairness
really
of
a
the
question
situation?
of the discussion, right? And I suppose it's what's attainable within a budget.
It's also a further discussion about the inbuilt discrimination in a system that doesn't have a safety net to catch people like that, isn't it, David?
Yes. Well, as a matter of principle, I agree with you, but you then got to come along and say, what is it that you want assistance for?
Well, for
Just because somebody-
representation. I mean, in order that you have a legal representative in court and you're not standing up and doing it yourself.
Yeah, system doesn't work that way.
I know it
Did you know?
doesn't. That's the point I'm making.
Yeah, okay.
Kind of should. Let's quickly hear, if we can, from Sue in Mornington. Hi, Sue.
Oh, good morning, Virginia and David. I've just got a question about debt collection agencies. A few years ago, I received a debt collection notice for a debt that I'd never incurred. I'd never heard of the company to which I was supposed to incurred it. And, of course, straight away, I went to the police to seek a little bit of advice, and I rang the company. I followed up several times, and eventually they said, oh, yes, look, it's all a mistake. It's not you. That's the end of it. And then about 6 or 8 months later, I got another one. So I rang them again and I said, look, I've been through this with you before. This is not my debt. I don't know why you're sending me another letter. They followed up and they rang me back and they said, oh, we've scrubbed it. Are you no longer on file? So that happened. I've had 2 more notices since then. Now, the last time, I'm just sick of it and I ignored it. I'm just wondering, is there likely to be any consequence to doing that now?
Yep.
Well, Sue, probably not. There are a number of credit reporting agencies that have that run a database on which your name is likely to appear, and it might well be that the company that originally claimed you owed money made that report but hasn't done anything with it other than not chase them yourself. So have a look at getting your, and you can do it for free. It's not that easy to find out how, but you look on the internet for credit reporting agencies, and it takes about 10 days to 2 weeks, but you can get your own credit report and you can see what's in it, and then you can ask for it to be rectified if there are errors.
So I actually did that. The police recommended I do that, and there was
Yes.
nothing on there to rectify.
Then I would be going back again.
Oh, would you?
Yeah,
Okay.
I'd go back again and I would be making sure that it has in fact happened, and then
Right.
you might consider a complaint to the Privacy Commissioner,
Yes.
and it might, the next thing that I would then consider would be talking to getting the details of the debt recovery agencies who are chasing you
Yes.
to see whether they've updated their records.
I think they were supposed to have already done that. Because
Yeah.
I'll follow
Well,
my
or
advice.
it might well be that they bought a bundle of debts from a bank or something, and they've decided that you now owe them. So I would be they would be the approaches I'd be taking.
Good luck. We hope you manage to get a final resolution. David, great to have you on board this morning. Thanks for all your advice.
Thanks.
David Whiting there, your Melbourne solicitor.